other speakers. All participant lines are muted. Note the engagement icons on the left side of your screen. A copy of today's presentation is available in the handout section. To ask a question, enter it in the Q&A box. In the event your slide display lags behind the audio, we recommend signing out of any other programs as well as logging off your VPN. To catch up, press F5 to refresh the page or access settings to resolve technical issues. Today's webinar is being recorded. You can access the recording using the same URL used for today's live event. An evaluation survey will follow at the end of the webinar. You must be logged in as an individual.
Our presenters today are Sharon Carroll, Compliance Business Consultant, and Dan Lias, Business Consultant for CT Corporation. Without further ado, I would like to turn it over to Sharon Carroll. Welcome, Sharon.
Thanks, Aisha. And good afternoon, everyone. Thank you for joining us. I know this topic we have focused on in many years past and present. It's always great to get an update. Things change, and that's, I think, the most important thing is trying to keep up with that. So our agenda today is I'll be taking the first half of the presentation, just going through some basic entity governance, compliance discussions, life cycle of an entity. And then I'll be turning it over to Dan, who'll really take a look at, what happens if we're not fulfilling some of those particular deadlines or items that we should be actually participating, either keeping track of or being able to report on. So let's get right into entity governance and compliance. And to me, this is really just a catch-all phrase. It's about what do you do, whether that's from the legal department, the tax department, any other department that might be involved in actually identifying what the entity structures are, what we have to do to stay in good standing, as well as some of these general terms. So when we're managing our entity structure, why are we doing it? We're doing it not only to meet deadlines, but also to gain some amount of success in our businesses, to mitigate risk. That's always a big one. Making sure that we can get a company profit, making sure that there's good brand identification. And all of these strategies are not only good for the day-to-day business of companies, but also give us the ability to change. And of course, with the ever-changing regulations, we're going to mention a few of them today. It's always important that we're always ready to go so that we're on the even keel, we're tracking everything, we know what our deadlines are, and making sure that those processes are maybe written down somewhere. We have them documented so others can also have an overview of that information. And if someone new comes into the organization, that they can follow along and make sure that as they come in and identify new compliance requirements, that they've got the old ones already in place. So let's spend a little bit of time on the life cycle of an entity. So when we decide to create a new entity, we've got to have that internal discussion. What's the need for it? Are we using our internal counsel? Do we use outside counsel to be able to do that? What should the structure be? Officers and directors, getting tax involved in that, even HR and employment details, and even think of that entity full circle. So what happens at the end of life? So that can be everything from the name we pick to the jurisdiction that we identify as wanting to form in, as well as register to do business, because those will follow the lifespan of the entity itself. So I put together, why create a new entity? And I would urge, all organizations to have some kind of flow chart or bullet point agenda about items such as this. So why would we want to create a new entity? Is it a value creation? Again, taking into mind what the compliance rules will be, the risk management, How do we protect that value? Is that in the naming? Is that the officers and directors that we identify for that particular entity? It's going to be a real combination of those. So having kind of a structure already determined for your company can actually help you follow and be able to insert or extract different components as things do change in the compliance world. So this can be, we start at this structure and we all get together and we meet and we talk and we decide what we're going to do for all of these. But I think having these as a standard also allow great transparency within your organization, and to be able to share that if anybody were needing to get some of that information on, what was the why, who, where, what, when we decided about that particular entity. And typically the first thing we have to choose is what type of entity structure do we want to utilize? And sometimes this is preference by company. It's preference by the kind of liability that certain entities can be utilized to protect our officers and directors and actually the entity itself, or even partnerships. So again, I would urge that you have an identification process of what type of entity we want to go with. Take a look at what that structure is. Now, I've got kind of a general formation and regulation commitment items here, but remember that they're different in every state. So sometimes corporations are treated the same as LLCs in a state. Sometimes they're treated very differently. Same thing with your general and limited partnerships, even joint ventures. So keep that in mind when choosing that legal entity type. It's going to follow that entity through, or do we know eventually we may go into some conversion process, corporation into an LLC, or vice versa. So I took this information and just wanted to provide kind of a breakdown by the entity type, and this is available in your handout because it really does show you what are the commitments for making sure that a corporation stays in good standing. The same thing for your LLC, general partnerships. And some of these may be, we can knock them right off the list because we need more liability. We want more coverage. We have more structure than just a general partnership or a limited partnership. So these are really the things that help define not only how you're going to start and create that entity, but all of the processes that will be tied to that entity as it goes through its lifespan. So here we've got some information on management structure. So the difference for your corporations having officers and directors, your LLCs having members and managers. And then of course, transfer of interest. If we know eventually that's something that's going to change down the road, we'll want to make sure that we have the correct entity type, or know that we may have to do some type of conversion down the road to make sure that we've got the entity type that we want. So something as simple as the entity type and the jurisdiction can play a very large role in keeping that entity in compliance and in good order. So I've mapped out kind of what we call the life cycle of a subsidiary. So I like this graphic because it really does show the movement from start here on the top level in blue, and we go all the way through. So from forming the company, making out those plans, to actually doing the documentation. So not only the internal, but whatever you need to file with that particular state. What are the ongoing filings and regulations? And what are the organizational activities? I like to keep that kind of as a grouping because it's kind of what we do every day, and how does that affect? Are there more rules for the corporation versus the LLC? Again, that's for each company to make a decision on, but I wanted to bring those up so that they do become part of that discussion. And then if we look at the life cycle on the second half of the slides, in the bottom portion in black and the top portion in black, just what happens when we decide that we don't need this entity any longer. Do we have other types of documentation that we have to go through? Is it qualified in other states? Do we have a filing and withdrawal process? And also, as part of this life cycle of a subsidiary, I also wanted to mention when things change. So I talked a little bit about what about post conversion if we move from a corporation to an LLC? What are all of those regulations, whether they be at the state or internal office tracking of information? What about the change of a principal place of business address? There's lots of states that like to have that follow-up information, and even a change in officers and directors. So although I've included kind of the particulars, I just wanted to share that in the broader scheme of things, there's lots of different information that you might need to follow up on a regulation that has been changed because of some change within the entity itself, and wanted to make sure that that's something that you keep in mind. And I don't know if that's something that you rely on outside counsel or your law firm partners to help with, or if you have someone internally who's tracking and checking what types of changes have occurred, and if indeed there is a regulation that you might need to comply with. And some of those things are things that get overlooked. They're small. It doesn't, someone thinks they don't matter. It's always great to ask the question, check the state statutes on why that might be important and what we might have to file. So I broke this also down in just some easy slides to understand, such as forming an entity. Do we go out and check that name availability to make sure that it is unique enough? Some states have rulings that names can't be too similar. They've got to have something that makes them unique. Making sure that we maybe register that name, especially if you're working on a big planned project. I always say better to have that name reserved, whether you know what it is, or if we just go in and reserve something that's a placeholder. We want to make sure that when we're moving forward, we can definitely guarantee that we've got the accuracy of the name. Filing the articles of incorporation or articles of organization, LLC agreements, making sure that we've identified a registered agent. And as you'll see, as you go through most of these, this is work that can be done by someone within your organization. You can use an outside vendor to do that, outside law firm, but it's good to have that checkoff list to know, are we going to appoint a registered agent? We know that's a requirement. Do we want to use someone internally? What are the pros and cons to that information? Same thing with business licensing and permits. I know in certain lines of business, there are entire departments that do nothing but track those business license requirements, reservations, renewals, permits. Same thing for any assumed names or DBAs that might be filed, even trademarks, if you want to go that far. So it's really understanding not only what the rules are, but do we have that department or individual or vendor who is functioning to make sure that they are taking care of that. Whether that's applying for EIN numbers, that's kind of a simple process. State IDs come typically with your regular filings of your articles or organization papers, but also to have some way to start tracking all of that information. So I've been in this business over 20 years. So we had the original corporate records kits, 3-ring binders with our corporate seal, and we had rooms full of these. Now we have ways to manage that electronically. So either way, we've got to make sure we've got a place for that information. So when we need to refer back to it, it's very easy to find. And then, of course, any other regulations that might be tied to a particular state requirement. We have a number of states out there that require publication of a new entity in the newspaper, which is interesting. I'm not sure how many people are still getting newspapers or getting electronic copies of newspapers, but we're also seeing these types of regulations change. So the other thing I just wanted to mention was, we all know once we get an entity formed, we're going to have some regulations, some requirements for us to keep it in good standing. And so we can actually do that with kind of a combination of internal functions and external functions. So some things that we'll be doing internally, so corporate record keeping, whether that minute book is electronic or hard copy, holding the annual meetings, our officer and director elections, any amendments that might happen. And then again, the first thing we perform internally, the second is where do we have to file that at the particular state. So these are kind of the first column, kind of the basics. The second column, what happens when we merge, we acquire, we spin off? Do we have to go through and take a look at that name availability again? Register a DBA? Do we need to also take a look at how that affects the qualifications of that particular entity, even the evidence of amendment? So I think a lot of people that we work with have the beginnings down. They know that to do their annual report, they've got to meet that requirement every year. But keep in mind that any of these other functions do happen to change the structure and sometimes will require some type of filing, not only at the domestic jurisdiction, but at the foreign registered jurisdictions as well. And if you want to, I did put in a reference. So there's a hyperlink right underneath the name, maintenance, and organizational activity. It's just a link to one of our record keeping white papers on our WK site. It is something that has a smart chart by state on the requirement for, can records be just electronic? Do they have to be hard copy where they may need to be kept? And again, you'll notice in that chart that there is a different requirement for every state. So it's a great thing to have a reference to if you wanted to get a little bit more information about record keeping and what that all entails. And then, of course, once an entity has come to the end of its life cycle, how do we dissolve that? Not only in the domestic state, but any foreign jurisdictions. So we have to withdraw some of those. How are we going to go through and cancel, whether that's business licenses, assume names, renewals? There's lots of different ways to be able to do that. Each of the states will let you know what their typical requirements are, but it's making sure that we've tied up all the loose ends. Oftentimes companies who have very common, name identification will want to protect that name. So we may keep that assumed name. We might keep that reference point so that no one else can take, and use that name again in a particular jurisdiction, or we might just let it lapse, or we might go through and actually go through that formal withdrawal process. But keep in mind, those are all of the different items that are going to affect once an entity finally does dissolve in its home jurisdiction. And then we still have some other work here to do at some of the other locations that they're registered to do business. And now we'll take a look at kind of an entity overview. So why is all this information important? We know it's for governance and compliance, but internally, we also may get a lot of these requests. It might be, I need an officer and director list for another type of filing. Do you have the registered agent's address, or did we change our principal business address, or even a name change? So these are the kinds of requests that you'll get from different departments. Do we need to get a new permit, license? We might need to get a good standing from the state. So all of that comes into the annual report compliance, making sure that we followed all of those rules by the state regulations to make sure that we can get that information so that indeed we can turn it right around and use it to apply for a license or permit. And then, of course, that internal information, who needs to take a look at what was filed at the Secretary of State? That really goes to the record keeping. and really something that really took off during the COVID era were electronic signatures. There were so many documents and so many regulations around wet signatures, and now most places will accept. There are still some holdouts, but what locations take electronic signatures? Can I register a company to do that? Can I file an annual report? Are there power of attorneys that could be in place? So all of these play into kind of the common practices. It's for each of your organizations to determine, is that something that we are comfortable with using? Maybe we don't want to use electronic signatures. Those are really up to each of your own organizations, but it's really identifying that, making sure it's documented so others are aware of that as well. And then just legal entity management. Do you have a department that is in charge of that? Is someone in legal tracking this information, or in tax? I've seen it divided between multiple departments. But it also comes down to, who are the data owners and who are the data editors? So who are the people who know those changes, whether it's new entities, officer director, changes in tax structures, and then who are those data editors? Who are those people that are keeping that information up to date, whether that is in a manual book, in a system, making sure that they could run a report on that information. Maybe they want to use some of that internal information to record deadlines on a calendar and make sure that we have email notifications so that we can share it. So it comes down to finding a centralized way to be able to track all of this legal entity management that can be easily referred to. And we've got some suggestions. Is that an online portal, a shared drive where you have this information? You might include your other policies and governance handbooks. It might include document templates, what meeting minutes might look like, what's the language we like to use in our LLC agreements. So having all of that tracked in one system or in one location really gives us the flexibility of keeping the train running, because other people can come in and see the documented information and follow that same information as they go and create new entities. If you might adopt an entity management system, it might make sure everybody has the correct training, people can edit, view information, and really make sure that however you're going to track that information, that it's easy for everyone to be able to utilize it. And then something that's happened in our industry is a lot of people are now outsourcing that information, and they might choose their outside counsel. They might choose a tax firm. They might choose a registered agent company, someone who could be a trusted partner. And that might be because we don't have staff that can be dedicated to that particular expertise. So do we find someone who we can partner with to make sure that we are keeping all of that information? And some of that information is tracking. A lot of that other information is making sure when regulations have changed. So, of course, the Corporate Transparency Act that's come up. And then just recently, we were sharing with some of our customers changes at the state levels. Evidently, Alabama on October 1st has decided there'll be no more annual reports. So those are the types of things to be made aware of so that we know in a regular process what we need to do, maybe what has changed. And if that comes from outside counsel or a vendor or partner, it will be very helpful to make sure we do stay in compliance. And now I'm going to hand it off to Dan, who's going to take us through some cases that have actually arisen from those questions about, have we maintained all of this information? So Dan, I'll hand it over to you.
Yeah, well, thank you, Sharon, and thank you all for joining us today. I guess I'll just say right out of the gate, Alabama must be taking that loss to Vanderbilt pretty heavy if they're canceling their annual reports. I mean, like, it's just a football game, folks. Kind of Netflix and chill there, but hey, it happens, right? Thank you guys, like I said, for taking time out of your busy day today to talk about entity compliance. Dan Lias, the transactional business consultant, as was said earlier, and my part of the presentation is more on the legal aspects of it. As Sharon indicated, going through a number of cases, statutory support, and et cetera, demonstrating like why there is kind of the other shoe to this issue that we're talking about, entity compliance. Sharon also did mention it just at the end of her presentation, so it does bear note that we do want to talk very briefly, right, about the Corporate Transparency Act. Now, again, the Corporate Transparency Act is new laws. For many of you already know this. It is geared towards a lot of our smaller. It's set up to be geared towards our smaller entities who have not had to submit information before to in this way. Now this is a federal law, but there is the proliferation now at the state level of similar requirements. New York, California. Well, California they've shelved it for the year, but New York is moving forward with it, and some other states as well. But the Corporate Transparency Act is part of compliance, right? And it's going to continue to be part of compliance, whether it is at the federal level or at the state level. Now, at the federal level, as you know, we have two different, and we'll just talk about this very briefly. We have some deadlines coming up at the end of this year. If by the end of this year, any entity that was in existence prior to January 1st of 2024 needs to get their information into the federal system, the BOSS system, the BOSS system. If you are forming entities this year, you are filing that as you are forming them, so to speak. And right now, I think there's approximately about 4 million or so filings so far in the BOSS system. I'm sure that number's gone up since the last time I checked the numbers. But again, it is part of compliance. And like I said, we won't get into the specificity, but yes, there are some ongoing lawsuits that are out there that are challenging the constitutionality of it. There's also talk of, there's some legislation at the federal level to try to repeal it and or amend it. And again, obviously in an election year, that's not going to be going anywhere. But just something that we have to keep in mind, right, is that this is part of our new compliance regime, all right? The one thing I will also add on to this topic, right, is that there is no case law, obviously, because this is so brand new, nor is there anything that we can point to in any of the rules that are coming out of FinCEN, at least presently, that say that non-compliance of this filing is going to pierce the corporate veil or things of that nature. Right now, it can be considered probably evidence. Let's be practical. It probably is going to be like, if you're looking at this as a scale, something that could be dropped onto that scale to determine whether or not that piercing of the corporate veil is going to happen or not. But it's not demonstrative. Like, if you don't do this, there is this penalty. There's nothing in the FinCEN rules or anything that would denote that. So certainly we just want to calm the waters on that front, so to speak. But it is something that, again, like all matters of compliance, if you do not comply with it, there are penalties, which we're going to be going through today. And certainly one of those that could, and I'm using the word could be, is piercing the corporate veil, again, if this is not something that you are complying with. But again, just right now, I would also highlight that if you do have any questions or comments about FinCEN, one of the best places about the CTA BOI requirements, highly recommend just going to the FinCEN website, folks, or reach out to CT. But certainly go to the FinCEN website. They do a phenomenal job of keeping everyone up to date as to their procedures and processes and things that they're rolling out as this new law becomes more and more integrated into our system. All right. So with that background on FinCEN, let's get into what the main thrust of today's presentation, which is the focus on what we would kind of classify as piercing the corporate veil, kind of in the generic, broadest way possible. And that's what we're here for, or at least that's why I'm here, is to talk about this, is that what is this veil piercing? Well, you can start with any definition, but we just found one from Wikipedia. It's a good one, which is basically it's the lifting of the corporate veil. It's a legal decision that treat the rights and duties of a corporation as the rights and liabilities of the shareholder. So really what you're kind of getting at here, right, folks, is that you have the corporate shield, which is really designed to protect shareholders' personal assets, whatever those assets may be, from legal activities, from a court case, both internal or external, right? Piercing of the corporate veil says you can, if that piercing is successful, those assets are now at risk to being used to, say, satisfy a judgment or things of that nature. So therefore, it is a very significant step in our corporate legal settings, right? And so it's not one that's taken lightly. I mean, we'll certainly go through that in greater specificity with the cases, but it is something that is available to folks if they raise enough of the issues that meet the standard. At the same time that we're talking about this, it's very important to note that piercing the corporate veil is one of those very elusive definitions, right? It is. I love this description by Chris Peterson because of the word murky, and I think that really is a great description of piercing the corporate veil. My definition of piercing the corporate veil and Sharon's definition of corporate veil, while they might be very similar, there will probably be some difference. There will be a little bit of light between Sharon and I, and that is, first of all, that's okay, because this is somewhat of an equitable issue. Not kind of, it is an equitable issue. And so therefore everyone kind of has their own idea as to what the solution or what the piercing the corporate veil should be. And so you have this variation that exists not only from state to state, right, but from actually judge to judge. So even if you're looking at this, like I'm currently a resident of the great state of Illinois, this judges in Cook County may have a very different opinion just inside Cook County itself. Not to mention Lake County or any other county here in Illinois can have very different opinions as it relates to the issue of what is piercing the corporate veil. So this issue, while it is on one hand very important and we need to understand it, at the same time we have to acknowledge that it is something that is going to be driven very much by the facts of each circumstance. So it's very hard to kind of get your hands around this and say like, oh, I know for sure that this is going to happen or this isn't going to happen, because this is such a subjective test that has been put out there on this. And again, it's an equitable issue for the courts to make a decision. And because of that, it is one of those things that is, like I said, a very hard thing to nail down. So again, as we're talking about this veil, there's 50 states. All 50 states have requirements to keep yourself in compliance, right? Well, guess what? Surprise, surprise to nobody. All 50 states have some sort of corporate veil piercing application or standard, if you will, right? It is not a separate cause of action, but it's actually a procedure that the court is going to use to enforce some sort of liability or some type of judgment, all right? There are a lot of distinctions between piercing the corporate veil via breach of contract versus a tort claim. I just want to get that level set right out of the gate. All right. Tort, like I said, a slip and fall, some sort of accident, and things of that ilk. The standards as it relates to that, as because you're complied, it's like an innocent bystander, if you will. The standards are much different in the vast majority of our states, as opposed to a piercing the corporate veil that comes through a breach of contract kind of dispute. In a number of states, that breach of contract, quote unquote, piercing of the veil has a much higher standard to overcome. Because again, the perception is that you're not the innocent bystander that, like I said, that slipped and fell on some ice or had some sort of accident with the company truck, so to speak. This is again where, because you're already in close connections with that corporation, the standards are a little bit different. All right. The other thing to keep in mind that in the vast majority of states, there is no distinction between piercing the corporate veil between corporations and LLCs. I say the vast majority because now I do believe that this has been quote unquote cured here in the state of Illinois. But we had a distinction here in Illinois between a couple of different court cases where a judge determined that piercing the corporate veil statutes were not applicable to LLCs because of how the statute was written. That does appear to have been amended, or the legislature has amended the language to make sure that does get addressed, make sure that courts ruling, I guess, is addressed in a way so that it's no longer applicable, or that ruling is no longer, doesn't have really, if we want to say, have any legs to it. So we can maybe say now with a little bit more confidence that, again, that all 50 states that's the case, but just something to keep in mind. But even though we've talked about this already, that there are these variations from court to court, variations from the states, there are some general rules that the courts do look at when looking at piercing the corporate veil. These are some of the big ones, right? Inadequate capitalization, for lack of a better term, you got no money, okay? But one of the big ones that we see over and over and over and over again, lack of compliance. People just aren't filling out and completing the forms that they need. They're not doing the basic day in, day out requirements that you need. I understand. Might be a little bit boring, might be a little bit, like I said, might be a little bit mundane, but understand this is vital. These documents need to be submitted, need to be kept up to date, need to be current. And if you don't, you run the risk of the piercing the corporate veil coming into your orbit. All right. And then another complete domination and control of a subsidiary, but basically it's just kind of like a puppet, if you will, of the other one. And then one of the other things that is growing, at least in a number of courts out there, is excessive fragmentation. And what we mean by that is simply, all of a sudden you had 4 subsidiaries and now all of a sudden there's 12, right? Things like that now seem to be getting the court's attention. Like, why all of a sudden are there all these subsidiaries? Like, what are you trying to do here? It creates the perception, at least in some courts' minds and some people who are bringing this procedure, that there's something afoot, right? To use a Sherlock Holmes statement, that there's something going on, right? And so while in and of itself, it's not enough to trigger piercing the corporate veil and having a court make that decision, it is something that, again, if that is something that is out there where you see a true, growth, if you will, in subsidiaries across the board, courts are looking at that with a slightly different eye than they were, say, 10, 15 years ago. Right. And so we have determined, or have a definition like what piercing corporate veil is, but we do have to understand that it does vary from state to state. And one of the examples that we have here is Texas. Okay. And one of the reasons that we've lifted up Texas is that because Texas has done something that is, I wouldn't say unusual, but it is something that is not, the vast majority of states haven't done this, which is that they've actually created a statutory regime as it relates to piercing the corporate veil. All right. And under the Texas code, and again, now this is dealing with breach of contract. So again, there's a distinction between breach of contract and something that is a tort. But under the breach of contract standards in Texas, look at the standards here, and we have it underlined. Under the Texas code, shareholders and affiliates cannot be held personally liable for a contractual obligation of an entity unless an actual fraud, primarily of the direct personal benefit of the shareholder or affiliate, right? That's a really high standard, folks, to pierce the corporate veil in the state of Texas as it relates to a contractual dispute. All right. And again, one other thing to keep in mind here in Texas is they've maintained and stated in the statutes that mere failure to follow corporate formalities, the things that we've been talking about, are not a basis to hold a shareholder or affiliate liable or piercing the veil. Now, again, this is for breach of contract, not tort. There's a very different world out there as it relates to tort standards and things of that nature. But again, this kind of demonstrates what a state can do if they so choose to, for lack of a better term, to get involved with defining what piercing the corporate veil is. Now, the vast majority of jurisdictions don't go the length that Texas has done, right? That's just not something they do. They leave this up much more for the courts to determine what that quote unquote is. But again, the states have the right to do that. Legislatures have the right to do that. Texas isn't the only state that's done that, but Texas is by far the one that has done the most in terms of determining what piercing the corporate veil is, right? But just as, as a version of Texas, there's also a version of Minnesota, all right? And what Minnesota did, right, and I think this is what you say is much more mainstream in the country, is Minnesota says, well, our statutes permit piercing the corporate veil, all right? However, what we're going to do is we're going to leave it up to the courts to somewhat determine what that piercing is, or how to determine what that piercing is. So statutorily, yes, it's permitted, but the courts will be able to create, if you want to use this, the standards. Now in Minnesota, it's a two-pronged test, all right? The first test is the number one, relationship of the shareholder to the entity, and the other is piercing the veil is necessary to avoid some sort of unfairness, or as they like to use the word, injustice, right? Now, to get underneath that and go to the next level, well, what do they look at to determine these two prongs, right? And again, a number of states have a similar two-prong or three-prong test, but what do they look at? Well, the courts in Minnesota have said, and again, just one state, but we can follow along here. Insufficient capitalization, as I already mentioned. Failure to observe corporate formalities. Again, I mean, this sounds like a broken record. Failure to pay dividends. And we just see going and going and going, like non-functioning of officers or their directors in all these things. And then but 7 that we did highlight here, lack of corporate records. And again, so much of what you see here in Minnesota can be duplicated across a number of states, is that you have it within yourself, corporations or whoever's in charge of this, whatever department is in charge of this, and or what law firms are helping with this. You have the power within you to avoid this. You really do. Just keeping the records up to date, making sure that you're in compliance with the state requirements across the board, making sure you have adequate capitalization. These are I don't want to say no-brainers, right? But these are pretty just fundamental basic things. And yet time and time and time again, people don't do this. People just let these things slide. And then when they let these things slide, unfortunately, piercing the corporate veil is one of the events that can happen if you are not in compliance, right? Which kind of gets us to a couple of the cases that we were wishing to talk about a little bit. And here is a case out of Illinois, personal injury case. Again, we had a situation where someone fell through a floor of a mobile home, if you will, and they sustained substantial injury. All right, so they went lawsuit ensued. All right, and what happened here is that they discovered this incredible patchwork of entities, a parent company that had all these different subsidiaries, and again, one subsidiary owned the property that the manufactured home sat on. Someone did the marketing. Someone actually owned the manufactured homes. Like, it was all just all different pieces that all led up to one main owner. But during the discovery, this is some of the things that they determined. Right, it's like that there was one company was like paying all the bills of all the other companies. That there was kind of like they had the same officers, same directors, things of that nature. And so a judgment was rendered against one subsidiary, and they wanted to enforce that judgment or pierce the veil of another subsidiary, one of these others of this large company. And so the question became, can veil piercing be applied across to a co-subsidiary or a sister company? Because again, judgment was against one, but they determined that the money, so to speak, or where they needed to get the judgment, was at this subsidiary where literally all the checks were being cut. And so again, here in the state of Illinois, what they did is that they said, well, it's grounded in equity. Veil piercing is grounded in equity. It can be the extent and type of cross-subsidiary veil piercing is going to be permitted, But so that was first and foremost. They said, yes, we can do this. We can pierce the veil of a subsidiary. All right. But this is the thing that we're going to look at here in the state. These are our standards that we're going to take a look at in the state of Illinois. All right. Unity of interest. Is it so strong that there's no separation between the two? Adherence to the corporate fiction, or would basically create this injustice or fraud. So what did the court look at? Well, these were the things they looked at, right? Again, there was no arm's length transactions between any of these subsidiaries. It was all just, for a lack of a better term, it was all just kind of, it was a family business, right? And they treated it as a family business. And that came back to bite them, right? Absence of any corporate records. Again, some of the subsidiaries, they kept records. Most of them, they didn't, all right? Failure for there was failure of almost all what we would consider corporate formalities, all right? And the reality of it is that they said they knew exactly what they were doing here, right? That they were doing this, they had created this structure to create this scheme, if you will. And it's something that unfortunately has created this environment where they could get their veil pierced and the judgment could get satisfied with this company. And if you just give me a second here, folks, unfortunately, very, very quickly here, I have a pet that is in a little bit of a distress. It'll give me 2 seconds only. I'll be right back. Hold on for just a second, guys.
And I'm sure all of us understand
Yeah,
the remote working from home. Yes.
I apologize about that. Crisis averted. I thought he was. I apologize, you guys. I thought you might be hearing him. He was having a little bit of a tantrum back there, and I'm like, okay, well, just you're on your own there, kid. So anyway, I apologize about that. But again, it just demonstrates, like in this case, they had this like some of the same officers, right? Across all of the subsidiaries, all right. All of the record keeping and all the bookkeeping flowed into one, and this subsidiary was paying the bills of the other subsidiary and all this. There was no separate, distinct accounting going on. And so while someone might say like, well, that's a no-brainer, but understand, folks, this happens over and over and over and over again. If you look at the sheer volume of veil-piercing cases, one of the things that you just see over, it just, again, like it's a broken record. It's like that Bill Murray movie, Groundhog Day. It's just that no one keeps the records. No one is doing the what is necessarily needs to get done. And again, it's unfortunate that happens. And some people just shrug their shoulders and, well, what's the worst thing that can happen? Well, this is the worst thing that can happen. Your veil can get pierced, and this very significant monetary judgment is now going to have to be paid, right? So again, it may seem simple, but it's surprising, really is surprising how many people just don't do this. Just don't do this, right? And again, I haven't scared you enough. Another case. This was out of the great state of North Carolina, right? Now, again, unfortunately, we had a failed corporate venture here. The corporate records, while intended to be set up as a parent subsidiary framework, became quite muddled. And I think that's being polite here, with another separate entity that was not part of the initial discussions. This truly, again, decisions that needed to be made weren't made at the beginning. There wasn't anything in this particular case, nothing was put down on paper. There's a lot of handshakes and quote unquote understandings and things of that nature, right? Well, unfortunately, this is a deal where this became a dispute between the business owners, right? And also some other people, but pretty much this became a dispute, an internal dispute. And the company was set up there was no meetings, no stock was issued, and the primary owners was a mom and a son, all right? And the question became, okay, the piercing a corporate veil issue was raised by the fellow business entities. They went after the mother and the son. Now the mother was really not part of this deal. She was not semi-retired. She was retired. The son was doing all of this. And so the question became, is like, did the plaintiffs prove the standard of veil piercing, number one? And they named the mother as one of the people that they wanted to pierce this veil to get to. And she had absolutely no role in this at all. This had truly all been her son's actions, who had acted as her agent. So the question became, in this particular case, well, can that happen? Can the agent, quote unquote, in this case, the son, bind the mother's, his actions, bind the mother into this veil piercing and therefore get to her assets? Now, here in the state of North Carolina, went through the same kind of standards, like entities of mere alter ego. Again, ego, you can see that this is very repetitive to some of our other states. To continue the corporate fiction would again create this injustice that's out there, right? So the court said, all right, let's look at the facts, right? And again, here we look at these facts. No funds, right? No compliance of corporate formalities, lack of separate entities, fragmentation all over the place, all right? And then the North Carolina court goes a little bit further than, say, what we saw with the state of Illinois. They looked at things such as level of control, right? And just exactly who was kind of moving the levers, if you will, of the company. And they said, seriously, that this, even though she was retired and really wasn't involved in this, the son was so involved with this and was moving those levers, if you wanted, the corporate levers on her behalf, that there really wasn't a distinction here between her and her son. He was truly acting on her interest, if you will. So they did allow the piercing of the corporate veil to go towards the mother as well as her son, or in this case, the agent and the principal. But again, if you read this case and other cases over and over and over again, this lack of formality, and then like in this case was at its absolute extreme because they didn't even bother to write things down. They were just operating under verbal agreements and as they called them, business understandings, which I have no idea what that legal concept is. But again, it just shows that when it comes to these, and again, you may also think to yourself like, oh, well, how bad can it be? It's maybe a couple thousand here, a couple thousand there. A lot of these piercing the corporate veil claims can be millions and millions of dollars, folks. This isn't just like, oh, well, I had a slip and fall, and it's at $50,000. I shouldn't say $50,000 is not a big deal, but understand that piercing the corporate veil can become very significant, very expensive, and you need to be aware of that. All right, and I know I got it free, and I want to make sure I give everyone enough time here. Last but not least, folks, or not close to last but not least, there's Delaware. Now, understand the vast majority of our corporate activity does happen in the state of Delaware, so Delaware needs to have certainly some sort of address this. They have. Now, understand in Delaware, piercing the corporate veil is hard to achieve. Now, they have set up like the statutory and case law support for it. Here are some of the grounds that you can use in the state of Delaware to overcome the standard, or to meet, I should say, the standard of piercing the corporate veil. Again, you can see capitalization, insolvency, things of that nature, record keeping. Again, these are, again, starting to sound like same song, second verse. What makes Delaware, again, a difficult nut to crack on this issue is that the courts have stepped in and said, well, to prove these, right, you need to find what the court has defined as exceptional circumstances. All right. So not only do you have this statutory regime that you have to meet, but that regime standard is this exceptional circumstances. That in Delaware is an incredibly high hill to climb. So while Texas certainly has a rather, one would say a rather, maybe the highest of hills, because fraud and things like other than fraud, Delaware has also made it pretty hard to pierce your corporate veil because exceptional circumstances is not a standard that is easily met, right? Not only you have to meet the statutory standards, but then you have this extra burden that the standard has to be of this level, which again, the best practice of avoiding all of this, right, is maintaining entity separateness, right? You also see this woven into almost any piercing the corporate veil case, right, in one way, shape, or form. Keep your subsidiaries separate and distinct. Have their own officers, have their own EIN numbers, all these things that Sharon mentioned a little bit earlier. Again, you might not, you think, well, how big of a deal is it? It is a big deal. All right. And again, making sure that each subsidiary is capitalized. All of these things are vital if you're really wanting to avoid this incredibly heavy penalty that can come your way. And again, it's also important to, again, separate, again, something you see many times over, subsidiary, just FYI, guys, subsidiary A should never pay subsidiary B's bills. Those are the types of just examples I can lay out there that those are the things that cause a lot of issues. And you really companies need to make sure that they set up enough structure to avoid that, because those are the things that courts look at as showing us that piercing the corporate veil is going to occur. And again, that failing to keep that separateness is, again, courts are going to come in and crack you over the head, if they can, legally and speaking, and pierce that veil. So it's, again, you have tax exposure, you have liability of all types. I mean, this thing, you understand that once they pierce the veil, all bets are off, folks. Everything comes open. It's not just that case. Everything gets exposed. So it's really important that that we maintain that separateness, that we keep those records in place and all that jazz. All right. And so compliance reporting, tax, again, annual reports, tax reports, business licensing, assumed named, all these things are needed. Sharon mentioned them. It's important that you keep them in place. Again, if you don't do these types of very simple things, they can lead to piercing the corporate veil, right? Non-compliance overview, again, just very, very quick. But again, be mindful, and this is the one takeaway from here, be mindful what happens in one state is different than what can happen in another state. We've mentioned Delaware, we've mentioned Minnesota, we've mentioned Texas, but Colorado is different. California is different. My home state of South Dakota is different. So even if you do get familiar with some states as it relates to these issues, understand that the minute you go into a new state, there are different rules and different things you need to be aware of. And with that, I do believe my time is up. I'm turning the slides over to Aisha. Again, thank you so much for spending time with both Sharon and I today, and look forward to our presentations in the future.
Thank you, Dan and Sharon. Before we conclude today's webinar, I would like to go over a few evaluation questions. The first question is, please rate the value of today's webinar content on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Once again, that is, please rate the value of today's webinar content on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. And moving on to our second evaluation question. Please rate today's presenters on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate today's presenters on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. And moving on to our third question. Please rate today's written materials on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is, please rate today's written materials on a scale of 1 to 5, where 5 is the highest and 1 is the lowest. And moving on to our final evaluation question. Please rate today's webinar technology on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Again, that is please rate today's webinar technology on a scale from 1 to 5, where 5 is the highest and 1 is the lowest. Thank you for joining. This concludes today's live webinar. You may now disconnect.